So the Supreme Court broke politics. How do we fix that? And how do we fix, or for that matter, get control of an out-of-control Supreme Court? It's a really vital question. Check it out. Leave your comments, ding the bell, share this with your friends, and subscribe to our channel. So what do we do with a Supreme Court that is out of control? Franklin Roosevelt faced this. Actually, the country faced the possibility of this after Lincoln was assassinated. In fact, let's just go back. One of the ways, there's two things in the Constitution, Article 3, Section 2, about what you can do with the court. One is you can regulate it. The other is you can create exceptions to what the Supreme Court may do. So let's take these one at a time. The regulated part. Typically the way Congress regulates the Supreme Court is by determining how many members it has. Congress can also determine when it meets, where it meets, what its budget is, and can even prescribe rules for it, like ethics rules, which I think would be a really, really good idea. Passing a law that says the Supreme Court has to comply with the Federal Code of Ethics for federal judges. The Supreme Court is exempt from the Federal Code of Ethics, which is why Thomas and Scalia were able to go to all these Koch brothers events and get paid big speaking fees and get feted at five-star resorts like the one, the hunting retreat where Scalia died, things like that. So, an ethics thing. But when Lincoln was assassinated, Andrew Johnson, a slaveholder and a Southerner, became president. Lincoln's biggest mistake, putting this guy on the ticket with him for his second term. And Congress, which at the time there were 10 members of the Supreme Court, and Congress was so horrified by the possibility that Andrew Johnson might appoint somebody to the Supreme Court, that they immediately met and passed a law reducing the number of members of the court to 6, so that up to 4 people could die before Andrew Johnson would have a chance to put somebody on the court. Andrew Johnson lost the election in 1868. Ulysses Grant became president. In 1869, when Congress met, they got together and they said, okay, that's it. We're going to take the court back up to 9 people, which is where it is right now. So they nakedly, for purely political purposes, changed the number of members of the Supreme Court. Then in 1937, from 33 to 36, the first term of Franklin Roosevelt's administration, Congress kept passing great laws, child labor laws, minimum wage laws, right to unionize law, just a whole series of really great pieces of legislation. And the Supreme Court was knocking down almost every single one of them. So he wins re-election in 36. He gets reinaugurated in 37. And the Social Security Act is coming before the Supreme Court. And the word is that they're going to strike it down as unconstitutional. Just like they struck down child labor laws as unconstitutional. Just like they struck down the minimum wage law as unconstitutional. And so Franklin Roosevelt says, I'm going to propose legislation that will say that all of the justices on the court who are over 70 years old, collectively, they'll still be on the court. The Constitution doesn't say you can kick them off the court. Federal judges have their jobs for life. They'll still be on the court. But they will have one vote among them. They will be justices emeritus if they're over 70. And there were 5 of them on the court at the time who were over 70. And then I will replace the missing 4 votes by adding 4 new members to the court. It was called a court packing scheme. If you read the Wikipedias and things of today, everybody says, it's so unpopular, FDR took so much flack for that. In actual point of fact, if you read the histories, as I quote my book, that were written in the 1940s, 50s, and early 60s by people who were actually there, it was very popular. There was a very good chance that Franklin Roosevelt would have gotten this through Congress. It had a lot of public support. And the only reason he didn't need to go forward was because Justice Owens and Justice Roberts, in response to public pressure, frankly, changed their votes. They started voting with Franklin Roosevelt, and that put an end to the court packing scheme. And then FDR, replaced, I believe, every single person on the court. Maybe there was one he didn't, but I think he replaced the entire court over the course of his 4 terms in office. And so you had a relatively moderate court going into the Eisenhower administration and the Kennedy administration as a result of that. And then, Nixon committed treason and became president and started packing the court. So one thing that we could do is actually change the makeup of the court. And Elizabeth Warren has suggested this. Say, okay, we're going to go to 13 justices now, and I'm going to be putting some on. Or we're going to stagger when they go on and when they go off, and then we'll move them off the Supreme Court back into the federal bench, which is okay with the Constitution. And so every president will get to appoint one or two or something like that. I mean, there's these plans to reorganize the court. That's one possibility. The other is something that a young lawyer was given the job by Ronald Reagan to figure out back in the early 1980s. Reagan was swept into power by a Supreme Court decision in 1976, Buckley, and then in 1978, First National Bank. These two decisions opened the floodgates to billionaire and corporate money for federal office. And so in 1979 and 1980, just gobs of cash flowed into the Republican Party and made Ronald Reagan president, in addition to cutting a deal with Iran to hold the hostages and make Jimmy Carter look weak. And as that money came in, Reagan, a couple of Reagan's campaign promises were that he was going to reverse Brown versus Board of Education, the 1954 decision that said segregation is illegal. He was going to reverse that. And he was going to reverse Roe v. Wade, the 1973 decision that gave women the right to have an abortion. Now, in some states, women already had that right. In other states, they didn't. And, there's a whole kind of thing here. But he said, we're going to reverse these two decisions. So he hired this young lawyer, brought him into the Justice Department, said, here's your desk, here's your office. You got a year to figure this thing out. This lawyer did a deep dive into the founders, into Hamilton's writings, Jefferson's writings, the Madison's notes on the Constitutional Convention, the history of the Supreme Court, the history of judicial review throughout the years, and ended up writing a 29-page memo that was like a small nuclear bomb going off in the Reagan administration. And what this young lawyer said was, according to the Constitution, Congress can create exceptions to what the Supreme Court may do, what they may rule on. So all we have to do is have Congress pass a law saying that segregation of schools is, in fact, legal, and states may, in fact, pass laws forbidding abortion, effectively overturning Brown and Roe. And then the last sentence of that law has to be something to the effect of, and this law may not be reviewed by the Supreme Court. He said, just write that into the law. It has been done in states over the years. It's called jurisdiction stripping or court stripping. It has, and it's actually been done in some federal laws, have been written with that clause in them, but they were never controversial things. Tom Daschle, when he was Senate Majority Leader, got language similar to this in one of the farm bills, according to Phyllis Schlafly. But, it was never litigated. Now, the decision that the Reagan administration came down to after this young lawyer came up with this whole long memo and said, just do this, the decision that they made was that, doing such a thing would it would be a political bomb going off. And it would set up a battle between the legislative branch, which the Republicans controlled then, and the executive branch as their ally, and on one hand, and on the Supreme Court on the other. I mean, the Supreme Court could say, wait a minute, we're going to rule that your law is unconstitutional. Your law saying that we don't have the power to rule on something. And they felt like they didn't have a large enough majority in the House and Senate to take on the Supreme Court like that. And so it never went anywhere. It just sat in a drawer until I found it last year. That young lawyer, by the way, that Reagan hired, who came up with this idea about here's how you neuter the Supreme Court, his name was John Roberts. He is right now the Chief Justice of the U.S. Supreme Court. He's the guy who went down to Florida in 2000 when he was clerking for Rehnquist, the Chief Justice of the Supreme Court, and advised the Republicans, along with another young lawyer named Brett Kavanaugh, advised the Republicans on how to put together their arguments before the Supreme Court in Bush v. Gore to stop the recount in Florida, which had it been completed, and we know this because, the votes actually got counted a year later up in New York, where they took semi-trucks, took all the ballots up to New York and hand counted them. It took a whole year. The New York Times, the Washington Post, the Associated Press, and Gannett did it. And what they found was that Al Gore won Florida, period, by any measure. But in any case, John Roberts, helped advise them on how to argue this thing before. I mean, this guy, he's a serious political player. So there's a few ways that we can get the Supreme Court under control. There's whether it's packing the court, whether it's, start with simple stuff, judicial ethics. Essentially create term limits saying, okay, you serve on the court for 15 years, and then after that, you go back to being a federal judge in whatever circuit you came from. You go back to the Third Circuit or the Fifth Circuit or the D.C. Circuit. That's all completely constitutional, easily done. But there's this fundamental argument. Hang on.
You're listening to Thom Hartmann. Visit thomhartmann.com for audio and video archives.
This fundamental argument, do we want to continue to live in a constitutional monarchy, or do we want to go back to being a democratic republic?